Good evening, ladies and gentlemen. I am Shruti Krishnan, fourth year law student at School of Law, Sastra University, and I'm extremely happy to take you through the proceedings of Lawgical Connect, brought to you by Sastra University, School of Law, in association with Times of India. By means of invocation, the being awakens, and the awakeness becomes fullness. Let us begin with a mellifluous invocation to be rendered by Ms. Charanya, a 2011 graduate of Shastra University.
Maitrim bhajata akila hrijetrim, Maitrim bhajata akila hrijetrim, Atmavadeva Paranapir Pashyata, Atmavadeva Paranapir Pashyata, Yuddham Tyajata Spardham Tyajata, Yuddham Tyajata Spardham Tyajata, Tyajata Pareshva Kramamakramanam, Tyajata Pareshva Kramamakramanam, Maitrim Bhajata Akhila Hrijetrim, Janani Prithvi Kamaduhaste, Janani Prithvi Kamaduhaste, Janako Deva Sakhala Dayalu, Janako Deva Sakhala Dayalu, Dhamyata Dhatta Dayatvam, Dhamyata Dhatta Dayatvam Janata, Shreyo Bhuyat Sakhala Jananam, Shreyo Bhuyat Jananam, Shreyo Bhuyat Sakhala Jananam, Shreyo Bhuyat Sakhala Jananam.
I have the pleasure of inviting Dr. S. Vaidya Subramaniam, Dean, Planning and Development, Shastra University, to deliver the welcome address.
Very distinguished jurists on the dais, special invitees, ladies and gentlemen. I'm extremely happy on this momentous occasion to welcome all of you to Lawgical Connect, organized by the School of Law at Shastra University in association with the Times of India. I must at the outset admit that I'm not a lawyer, but a reasonably active litigant and hence a student of law. And I must also confess the feeling of dwarfness that I have in me in the immediate presence of the legal giants who have gathered here this evening. In fact, 2 months back, when the School of Law at Shastra University wanted to organize a program of this type, I suggested that we could have the name for the event, the legal Kumbh Mela. But then it also occurred to me that you see, in Kumbh Mela also we can predict that it will happen once in 12 years. But ladies and gentlemen, I don't know at least, when will Chennai be able to host a gathering of this type, an aggregation of 300 years of judicial wisdom packed in one single stage? And the manifestation of that in physical form, ladies and gentlemen, makes this event so special. And I request all of you to put your hands together and welcome these distinguished jurists to this city of Chennai. 20 years have gone since the collegium system of appointment of judges was in place in this country. Whether this self-selection mechanism has attained the desired objectives after the interpretation of the Constitution itself was strained so much is a question that we are not going to seek an answer for this evening session. This evening session is for a different purpose. It is on the 120th Constitution Amendment Bill and the consequential Judicial Appointment Commission Bill. The question of the day hence is, does the proposed Judicial Commission guarantee judicial independence? There has been many views on this topic, ranging from one extreme on this side to the other on the other side. Being in Chennai, the Madras Bar Association also has expressed its view that the proposed amendment and the commission bill in its present form, it looks like it is a surgery using Article 368, remove the head of the judiciary of the Constitution, and then through 107, hand it over to the general ward of the parliamentary power for a cosmetic makeover. This is one view. There are also other views. But today, ladies and gentlemen, we are interested in listening to the views from those pillars of this judicial establishment. Proponents of the proposed amendment and the Judicial Commission Bill have a lot of reasons that many democracies have made this selection process a participative one, and so should India. It cannot afford to be unique, and hence we also should embrace this new method in the form of the amendment as well as the bill. And nobody is against it, that's how it appears to be. But whether the form in which it is presented today will ensure judicial independence is the key question for which this gathering here, as well as thousands of those who are watching this show live webcast, is expecting the views of this distinguished jurist who have so graciously consented to our invitation to address this gathering here. Ladies and gentlemen, and for the benefit of the jurists, last year we also associated ourselves with a debate on judicial activism where we recalled the role of the great jurist Nani Palkiwala. And after the event, it made a lot of headlines. But this event, Lawgical Connect, is not an event that is going to make headlines. Take it from me, it is going to leave a permanent footprint. And history will recall that if at all there has been an event of this magnitude to discuss about this constitutional amendment bill and the Judicial Appointment Commission, it has to necessarily reflect the proceedings of this evening, ladies and gentlemen. And that is why the School of Law at Sastra University is so happy to be a part of this historic event, and I welcome all of you to be a part of this history. Thank you very much.
As a token of appreciation, we would like to honor the distinguished speakers with a memento that symbolizes the temple town of Tanjavur and its edifice, Sastra University. May I now request Professor R. Sethuraman, Vice Chancellor of Sastra University, to present a memento to Mr. Anil Divan. Again, I request Professor R. Sethuraman to present a memento to Mr. K. Parasaran. May I now request Mr. Nainan Tarian, Vice President of Times of India, to hand over the memento to Mr. Ram Jethmalani. May I now request Mr. Sunil Nair, Editor, Times of India, to hand over the memento to Mr. Soli Sorabjee. May I now request Dr. P. Ravishekhara Raju, Head of Department, School of Law, Sastra University, to hand over the memento to Mr. S. Gurumurthy. Ladies and gentlemen, the time has come to establish the logical connect. May I now request eminent columnist, renowned thought leader, and a polymath beyond definitive intellect, Mr. S. Gurumurthy, to lay down the context and moderate the intellectual panel discussion on the question, does the Judicial Commission guarantee judicial independence? Over to you, sir.
It's a rare day and one of the happiest days in my life that I am sharing platform with such eminent men who also happen to be my close friends with whom I have interacted, not as a lawyer, but as a trespasser into law. In fact, they had entertained my irrelevant questions, and I have been a beneficiary of these men of wisdom, which made my clients feel that it is better to consult me on law than on accounts. You know, it's a very important day in Chennai that we are fortunate to have this discussion on the Judicial Commission bill. It should have become a law by now, but for an arithmetical error of somebody mentioning the Constitution Amendment Bill which was going into the Lok Sabha as 120th amendment instead of 119th, because of which the bill could not be passed in the Lok Sabha. Otherwise, by now it would have been passed and this would have become a law. And now we are trying to find how wrong it is. Because of that fundamental arithmetical error, we are still in a position to discuss the pros and cons of this great constitutional fraud, as Mr. Ram Jethmalani told in the Rajya Sabha. He will have more to talk about it. How this bill, it has a history. You know, before 25th April 1973, there was no question mark over judicial independence in India at all. It was on that day the Keshavananda Bharati judgment was delivered in the morning. And in the evening, All India Radio News Bulletin said that Mr. A.N. Ray has been appointed as the Chief Justice of India, overlooking 3 senior judges, senior to him, who gave the Keshavananda Bharati judgment, which said that the basic structure of the Constitution could not be amended, which went against the philosophy and the policy of the Government of India, and they were superseded. And all of them resigned. And Justice Sigri, who was to retire the next day, also symbolically resigned and said, this is the greatest blow that has been struck at the judiciary. At one stroke, the Government of India, the executive, the political power, made the judiciary feel how fragile and how weak it is unless something very, very substantial was done. And nothing happened. From 1973 till 1982, the next landmark date, was the SP Gupta judgment in which the transfer of judges were questioned and the Supreme Court virtually handed over the power to appoint the judges and the control over the judiciary to the executive. And from 1973 till 1993, when the second judges transfer case came to be judged by the Supreme Court, the executive had the complete power over the appointment of the judges. In 1993, the power came to the Chief Justice. Chief Justice's opinion was held to be binding. But in 1998, something very different happened. The Chief Justice, without consulting his colleagues, he forwarded names, and the executive found that there was no consultation process, and then came the presidential reference in 1998, which decided in 1999 that there has to be consultation within the judiciary, and that is how this collegium came. The collegium has been functioning effectively from 1999 till now, and it is functioning even today. But there is a broad consensus that this collegium has failed to deliver because of lack of transparency. Everything is being done in a manner, maybe if somebody has to take up this matter under the RTA Act or whatever, it has not been tested. But the government and the judiciary and the process by which the whole thing has been going on has been so lacking in transparency that this has been admitted to be a failure, and that is why there is a broad consensus that there has to be a judicial commission, has come to be recognized in the judicial circles as well as outside. But the manner in which this has been done, as if overnight this bill was cooked up, and instead of being one bill, it was turned into two bills, about which you will hear more from people who have handled it, who have discussed it, who have researched it, who argued in Parliament, and who are been so concerned about preserving the judicial independence of India. It is a treat that you are going to have, an intellectual and judicial treat, that how this whole issue is being handled casually in the judicial circles, in Parliament, even outside. In 1973, when the supersession took place and the judiciary was shaken, the whole nation was shaken. But today, there is no discourse, there is no debate, there is no concern. Even the media is treating this issue so casually. That's why when I was approached by Mr. Vaidya Subramaniam as to how to shape this whole topic, I said this should be related to the concept of judicial independence. It should not be whether it is really an issue between collegium or the Judicial Commission. I said we have to bring in the very concept of judicial independence, which was a matter of assumption. It was assumed. Nobody questioned it till 1973, April 25th. And so it's a larger issue. And we had a discussion in the morning, and I suppose the entire concept of judicial independence and how it will work in India and what is the implication of this bill on the concept of judicial independence will be discussed here. And all that I want to say today is that we have four great men. And not only I know about their judicial and legal skills, I know about them personally. I know Mr. Jethmalani. You know, we all questioned. In fact, I was one of the critics of him when he took up the defense of Balbir Singh and Kehar Singh and Byan Singh in Mrs. Indira Gandhi's assassination. I was a critic of him. How could you take it up? And finally, he got the Supreme Court to declare that Balbir Singh was not an offender. The case against him was false. If only he had not defended, that man would have been hanged. And he told me that if an accused comes and asks that you should be my advocate, it is a mandate which he gives to me and I cannot breach it. I couldn't understand it. But how important is that fundamental ethics? And I know Mr. Parasaran. You know, I was on the other side in most of the cases. In the Indian Express building case, where there was a demolition notice issued and we were fighting this case, he was the Solicitor General appearing on the other side. And the Supreme Court suggested, Mr. Parasaran, why don't you advise your government to withdraw these show cause notices. Mr. Parasaran didn't say, no, I will consult them and come back. He said, I will tell them. And he went and told them. The government did not listen. He gave up the brief. He refused to argue the case. He sent the resignation letter.
So, a judge must be able to stand up to the executive. Secondly, the Supreme Court and the High Courts are closely scrutinizing scams and corruption. This is making the executive very, very uncomfortable. They are not very happy at what the judiciary is doing because they are exposed to public scrutiny with RTE Act, etc. So this is something which was of great moment to them. And these bills taking advantage of the general at the bar. And what happens at the bar is, when there is dissatisfaction, we members of the bar, all of us, become angry. And when we become angry, we try to attribute all sorts of motives to the judiciary. Now please remember, we must make constructive criticism. But today, judiciary is the only hope, neither the executive nor the legislature, which can come to our rescue. So please, as members of the bar, it's our duty not to make irresponsible allegations, but only make constructive criticism, and please do not denigrate the judiciary. Why? Because by denigrating the judiciary, you are devaluing the judicial system, which is very bad for the country. And by devaluing the system, we are devaluing ourselves as lawyers, because ultimately we are officers of the court. And if the people do not respect the court, people are not going to respect the officers of the court. So please bear this in mind. Whatever criticism we make, we must make it constructively, in sober terms, and not to denigrate it because somebody else might take advantage of it. Having said this, what is the concept of the independence of the judiciary? And I would like to divide it in three parts. Historically, in England, before the Act of Settlement, the judges, the king's judges they were called, held their office at the pleasure of the king. They had no security of tenure. There was a big fight with Parliament. And then they were there for life, or if they behaved and were guilty of misconduct, then they could be impeached. So the first step in constitutional history was to secure the tenure of the judges. Their salaries, etc., could not be modified to their detriment. So that has been provided by our constitution. Security of tenure, non-removal except by impeachment. But there are two other things. One is, suppose at the appointment level, the politician has an overweening influence, an overriding influence, then you will have only pliant judges. So that is again a very important aspect. How are appointments to be made? And finally, with which we are not concerned today, is allurements post-retirement. These are the three elements which go against the independence of the judiciary. We are concerned with the first one. And it is necessary, therefore, to see that the right appointments are made, appointments are made of not people who can't stand up to the executive or to the administration. Having said that, taking advantage of this dissatisfaction, these bills have been put in. Now let me tell you, give you a few dates. In the press, this news came that they are thinking of amending the bill. So on 17th of April 2013, a letter was written by Bar Association of India, which was signed by M.N. Krishnamani, President, Supreme Court Bar Association, Fali Nariman, K.K. Venugopal, Ashok Desai, myself as President of the Bar Association, others. And what did we ask them? We said a permanent independent body with substantial lay representation and a transparent, open and broad-based selection system inviting applications, nominations from interested lawyers and candidates is adopted by other countries like the UK and South Africa. This is a model to be considered. We therefore request you to make available to the public a draft of the proposed bill to enable a healthy debate and discussion. We also request that such an important measure should not be rushed through without a robust debate and discussion which necessarily involves a reasonable time. April 17, 2013, no acknowledgement, no reply, no provisions of the bill given. For the first time, these two bills surface in the Gazette on 29th of August 2013. On the same day, the bill is tabled in the Rajya Sabha. In the Rajya Sabha. There is a 2-3 day debate, and on the 5th of September, the bill, the constitutional amendment bill, is passed by a majority of 131 in favor of the bill, one solitary dissent by Ram Jethmalani. I compared the days during the emergency where we were all very concerned. Even some of the constitutional amendments passed during the emergency were tabled and gazetted for more than 4 days, 29th of August and 5th of September. So this is again reminiscent of the hurry and scurry to take advantage of the general dissatisfaction. Because everybody says, without reading what the provisions are, oh, this collegium system is hopeless, let's get rid of it. And let's congratulate the law minister who has now come forward with this bill. That is the advantage they are trying to take about. Now, briefly, what are the provisions of the constitutional amendment bill and what is wrong with it? First, the original law as now being practiced by the collegium was that the Chief Justice's word was final and the word consultation was used as concurrence. Without the Chief Justice's concurrence, you can't make an appointment to the Supreme Court, you can't make an appointment to the High Court, and you cannot transfer a judge. That's the law, current law. They have amended it and said now all these three functions, appointments Supreme Court, appointments High Court, appointments CJI, and transfers will be on the recommendation of the Judicial Appointments Commission. But the mischief is not in that. The mischief is in Article 124, capital A. And I'll read out that article. 124A. There shall be a commission to be known as the Judicial Appointments Commission. Parliament may by law provide for the composition of the commission. Now today in the bill, the composition of the commission is Chief Justice of India, 2 senior judges, the law minister, and 2 eminent persons to be nominated by a committee consisting of the Prime Minister, the CJI, and the leader of the opposition. So it looks very nice, 3 and 3. But there is no provision if there is a tie, what happens? The Chief Justice doesn't have a casting vote, number one. Now, the mischief is, 5 years down the line, you have another government, another administration. They say we want to add 2 more, and 2 more, and 2 more. I want a particular community representation. I want a caste representation. I want a religious representation. So Parliament by ordinary law can completely destroy the composition of the Judicial Appointments Commission. Now take the case 2 other people are added so that the judges become in a minority. And they say, we don't like this convention of Chief Justice of India being appointed as the senior most puny judge. We don't like that. We will pick up a judge from amongst the other judges and make him the Chief Justice for 10 years because it's 6 months and 9 months and 10 months is no good. You can't stop it because there is a constitutional amendment and it can be done by ordinary law. So this is the heart of the matter. If the composition, whatever it be, and it should be preponderant judiciary, if it is put in the Constitution, the composition of the Judicial Appointments Commission, half the problems would be solved, but only half the problems, because there are so many other problems. The two other things which to be noticed are that the Secretariat of the Judicial Appointments Commission will be a government department. What is there today in the Supreme Court and the High Courts? The registry and the appointments of the officials is done by the Chief Justice of India or the Chief Justice of the High Court or the court. So they are court appointed, they are independent of the government, they are not government babus. You know how many tribunals and how many commissions have been undermined by not giving them sufficient stenographers or sufficient room or sufficient air conditioner. So the first thing, and another mischief is that it's being treated, Judicial Appointments Commission is being treated by a government department. That is no longer, that's not acceptable. Because once the judges are there, they have very little time, what are they going to do? Something will be supplied to them, something will not be supplied to them, they will have no time. And if the vacancies are not filled up, there will be a hue and cry, you are not filling up the vacancy. So the pressure will mount and the manipulation will be done at the government. So there is a second important thing is that the registry of the Secretariat must be by appointment by the court or the commission itself or by the Supreme Court or the High Courts, whatever it is. Third, the funds should be charged on the Consolidated Fund of India, salaries, expenses, etc. So they are completely independent. These are three very important things. Now, what the Judicial Appointments Bill does not address itself is the concerns of the bar, the concerns of the citizen. There is no criteria of transparency. There is no criteria that you should lay down a list of potential candidates. Today, under the UK new act, it's called the Constitutional Reform Act of 2005, the Constitutional Court of the UK, they invite applications, they advertise, and then there is a panel which makes a recommendation. The panel is predominantly judicial. Similarly, there is a 15-member Judicial Appointments Commission which appoints various High Court judges, etc., because there are High Court judges in England. They have to make an application, the thing is advertised, there are interviews, etc. In South Africa, when the shortlisted candidates are interviewed, the press and the media is allowed to remain present. Completely open thing. So this transparency is very important. One further thing is there is no consultation or inputs from the bar, either the bar councils or the bar associations, etc. This is a very important thing. The American Bar Association always evaluates potential candidates and makes its decisions and recommendations. So there is no reason why the bar, which is a very major stakeholder, ought not to be consulted. I am not saying bound, but at least advisory, interaction. And the last thing which is important is that if you are going to collect information, because nobody can now you have mostly outside Chief Justices. Outside Chief Justices don't know the conditions of the local bar. They are, somebody whispers in this year, somebody whispers in another year, somebody gossips something, etc., and somebody is knocked out. Now this is the most unsatisfactory system. So input should be invited with confidentiality and secrecy. But most important, it should not be anonymous, it should be under a signature, but no question of defamation or contempt. If somebody has, I have some information, I am not able to verify, I give that information that I have heard from reliable sources, this. I should not be exposed to defamation. I should not be exposed to contempt of court. So this, I think, requires serious debate. And if you hear the law minister's speech in the Rajya Sabha, he said we are here to restore the old system. In substance he said that, and the old system means they will have the whip hand under Article 124A to put in compliant judges, judges who are of the same view as the administration. This therefore now, what is today's topic? The topic is, does Judicial Commission guarantee judicial independence? My answer is, as framed, this bill is the gravest threat to judicial independence. Judicial commissions should be independent. If they are really independent, they will serve the purpose of ensuring judicial independence. And I think, and I've written about it also in the Hindu in an article, all lawyers, etc., we must get together and protest against this bill, because still it is to be introduced in the Lok Sabha. And before I conclude, let me give you an example of boldness and courage from a member, a leading member of the Madras Bar, whom I knew personally, and many of you might have seen him practicing in this court, the great Govind Swaminathan. I don't know, some of the lawyers have seen them. And what happened? In November 75, A.N. Ray, who had become Chief Justice of India, wanted to reconsider the fundamental rights case, Keshavananda Bharati, during the emergency. So he convened a bench of 13. Then one of the judges asked, maybe Khanna, that where is the judicial order by which this bench has been constituted? No judicial order, just constituted by the Chief Justice on the suggestion of the then Attorney General Niren Ray. So Ray looked left and right, and they said, yes, I think Tamil Nadu government wants a reconsideration. Govind Swaminathan was sitting in the second row. He got up and said, there is a clear misunderstanding, my Lord the Chief Justice. Tamil Nadu has never asked for reconsideration. Now can you imagine the courage of that man? His daughter was under preventive detention because she was indulging in some activities near a very prestigious farm. She had organized workers, so she was under detention. So whenever Govind used to come there, he used to go and meet her in Tihar jail. With that background, he had the great courage to stand up to the Chief Justice of India, and at that time nobody knew how long this emergency would last. So that's a model which we must all try to emulate. Thank you, ladies and gentlemen. Thank you for a very patient hearing, and I hope I have contributed to stimulate some thought and some action on the part of the lawyers present here. Thank you.
Now I request Mr. Parasaran to share his views.
My good friend Mr. Gurumurthy, the senior most member of the board, the whole country, the join of the board, Mr. Jethmalani, Mr. Soli Sorabjee, the former Attorney General, internationally renowned, and my good friend Mr. Anil Divan. When I see the gathering here, I stand with trepidation because I see great legal scholars here who probably many of you may know even more law than me. As a second handicap of being sandwiched between Anil Divan and to be followed by Ram Jethmalani. He is unrivaled in his advocacy. He was the one bold person who spoke dissenting voice in the Rajya Sabha. I am also a member. I did support the Constitutional Amendment Bill, but certainly not the way they are going about the bill, but the Constitutional Amendment that there should be, not a this collegium system should go, and we must have a commission. That I supported. But certainly when the bill comes, I had expressed my views within the limited time which will be allotted to a nominated member. But with an advantage that I am not committed to any party, because I did not opt to become a member of any of the parties within the 6 months' time. My good friend Anil Divan very generously referred to the great traditions of the Madras High Court. I owe a duty to say a word about the Bombay High Court. Because Bombay and Madras are complementary in the sense, if Chagla was their Chief Justice, Rajamannar was their Chief Justice. I don't know to say who is great between the two. Not only that, they are also giants. I have had the good fortune of interacting and appearing with some of the giants of the Bombay High Court. But I will only tell one instance because he said about Daftari, about Mr. Sastri. I will say about C.K. Daftari. He was leading Fari Nariman. It was a bench in which senior N.S. Bhagavati was presiding. He will know it. Then as he was making a point, Mr. Daftari, senior Bhagavati asked, Mr. Daftari, I have a recollection that I have decided this question sitting in the Bombay High Court. Immediately Nariman passed on the Bombay law reporter to him. He said, keep it aside. Continued his argument. After a while, Justice Senior Bhagavati, not P.N. Bhagavati, his father, he said, yes, Mr. Daftari, I now exactly remember that this very point was argued before me for the Bombay High Court, and I have decided this point. Mr. Daftari calmly said, yes, my lord, sitting in the High Court, we have decided this very question. But now that you are sitting in the Supreme Court, it is open to you to repent. This is the, you see, no, not insulting the court, respectful to court, a good retort with a humor in it. He was unparalleled in his humor, which today is very much lacking in courts. Because we are nervous, sometimes we grow, humor is mistaken. And if it is mistaken, tomorrow you yourself will be dismissed. This is the problem. Now, no doubt the topic of today is of great concern for all the citizens of the country. Because without an independent judiciary, democracy is finished. Therefore, all of us are concerned, every citizen is concerned with an independent judiciary. And I feel very fortunate, you must also be feeling, that I am in the company of such giants who are all experts in constitutional law. About the bill, you will hear very vehemently from Mr. Jethmalani. Therefore, I will not tread on that down. The topic being, does Judicial Commission guarantee judicial independence? No commission, no collegium, nothing can guarantee judicial independence unless those who are in charge of appointment and those who are appointed have the independence. We had good judges in the old system, in the first judge before the second judge's case. We had good judges after the second judge's case. We had bad appointments under the first judge's case and bad appointments after the second judge's case. In the present day system, who is an icon of the judiciary, have become a judge of the Supreme Court at all? Under the second judge's case, they go with seniority. And second judge says, one judge says seniority is very relevant because he is in the line of succession. Another judge who is not in the line of succession but says seniority. And he puts the reasoning, legitimate expectation. A judge of a high court to have a legitimate expectation to become a Supreme Court judge? I pointed it out to be in the presidential reference. Justice Barucha presided. The great jurist, Sorabjee appeared. He boldly said, the government will be bound by your advice. The law is the government is not bound. He told the court, law will be bound by your advice, he said, and argued the case. And he also said, we don't want the second judge's case to be overruled. We don't have law officers today like, we want our law officers like that today. So, you see how they went on legitimate expectation. The last stanza in the first judge's case, S.P. Gupta's case, Venkatramaya concludes by quoting a text. He says, let wealth come or go, or let those who know justice criticize or praise. Let death come immediately or after yugas. But people who are involved in the administration of justice will expect nothing, no expectation. Adyaiva ma maranamavi yugantareva. Lakshmi samavasatu gacchatu vayatetta. This is what he says. There can be no legitimate expectation. A judge can never have an expectation, much less a legitimate expectation. Once he accepts the office, he is wedded to the oath. This is what Justice Gajendra Gadkar said in the presidential reference. That was one of the early cases where the executive and judiciary was in confrontation. The court was put to test. Notice was issued for breach of privilege against judges of the Allahabad High Court. we had also good executive in those days. When they issued notice to 2 judges, it went for before 3 or 4 judges, there again notice went to them. The Chief Justice phoned up to the Chief Minister, Sujata Kriparani, the Chief Minister, the wise lady who are today being neglected. The best of arguments have been addressed only by 2 ladies. How many ladies we have got in the bar or in the bench? I will come to it a little later. The Chief Justice phoned up to her. What is happening, Chief Minister? She said, the remedy is in your hand. Why are you asking me? What is the remedy? Every judicial gives a notice, immediately the notice of process from the Legislative Assembly is coming. How is the remedy in our hand? It's only 2 judges or 3 judges. Supposing all of us sit in a bench, will they issue a notice? The entire judicial administration will come to a standstill. The next day, all the judges, I think it was in Lucknow, were there in that bench, assembled and issued the notice. The result was a presidential reference. And the Supreme Court rose to the occasion. It subordinated a fundamental right to freedom of speech under 19(1)(a) to the privilege of freedom of speech of a parliamentarian in the House, member of the House. Even a fundamental right subordinated to a non-fundamental right. But they said, right to life prevails over everything. Article 21. They protected the right to life. We had such executive, we had such judge. But unfortunately what happened? They were put to test. When they were put to test 26 years after the Constitution came into force, they got 20% and failed. Out of 5 judges, 1 judge had the courage to dissent. The remaining 4 caved into the executive. Both are only under the previous system. You had good judges, you had bad judges. Krishna Iyer was not a senior judge. I cannot verify it. Probably he had not put in 5 years as a judge. 5 years is one of the qualifications. But he had put in 10 years as a practicing member of the bar. I may be wrong, this is my recollection. He was taken as a member of the Law Commission. The Chief Justice refused to recommend his name. The succeeding Chief Justice, who came under wrong circumstances, he cleared his name. You see, we can't explain. That's why I say it is the men who matters. It is the independence of the judiciary. Is it the individual judges or the institution? We all know this, the doctrine of institutional integrity propounded by this noble Chief Justice Kapadia. Not only individual integrity, institutional integrity. Like that, independence is both an institutional independence and the individual judge's independence. And one judge had the independence to say I dissent in that Yadi and Jabalpur case. The remaining 4 did not have. But the problem is, in the judiciary is still our only hope. They have stood up. And without the judiciary, we are nowhere. Therefore, as Mr. Divan rightly said, we, the bar and the bench, have no right to let down the judiciary. Because we have, not that if they make a mistake, we should keep silent. We should criticize. But the criticism should be healthy and not attacking the judges personally. We should not at any time, because I used to openly say it, for 63 years, the Madras High Court and the Supreme Court, they have provided me my food, shelter and clothing. I have never let down the institution. But then the institution has no right to say let down the citizens. You are the only protection. And this is therefore for ensure independence of the judiciary. Therefore the bill is hopeless. It will not be debated in Parliament. We don't know what we will do. It's a democracy. In fact, the leader of the opposition very vehemently supported the bill. So a very good speech he made. Whether one agrees with him or not is a different question. The party was all supporting, except some 2 members who said it's unconstitutional. There, I also feel that they should make it by an amendment of the Constitution. They can't do it by a plenary legislation at all. Because all the provisions in the bill, subject to what should be the provisions of the contents of the bill, should be made a part of the Constitution. Otherwise, they can't touch 124. We had that recent experience in this disqualification of the Parliament, members of the Parliament and legislature. The argument of Mr. Farid Nariman was it is delegated legislation. The Supreme Court holds it is delegated legislation. It may not be absolutely correct. Because they trace the power saying it's not under 256, but under, I forget the numbers of the article, 193 or something. Therefore, it's a delegated legislation. The reasoning is wrong. All legislation are traceable only to the articles in the Constitution. The entries only demarcate the fields. Therefore, the court may not be right in saying it's a delegated legislation. But we get an example of, in the same article, the example of a delegated legislation and the example of a non-delegated legislation in the same article, which is Article 262. Article 262(1) provides for Parliament making a law for an adjudicating machinery in interstate water disputes. That's a plenary legislation, but not a delegated legislation. Sub-article 2 is a plenary legislation, but a delegated legislation. It says the Parliament can by law house the jurisdiction of all the courts, including the Supreme Court. The Parliament cannot do it. But because it's a provision in the original Constitution, that founding that is the Constitution could house the jurisdiction. That power they are delegated to them. It's a delegated legislation. This is the fine distinction. But anyway, without going to all those vulnerability and other things, it must be only by a constitutional amendment and not by a plenary legislation. This is the second aspect of the matter. Now please see, after the first judge's case, what's the problem? In the first judge's case, 124, we must go by 124 when that's part of the original Constitution. Ambedkar said in the Constitutional Assembly debates, a power, he says, the Chief Justice is also a human being. He has also got our failings. A power which we are not prepared to vest in the President or the central government or union government, we are not going to vest it in the Chief Justice. Then how do they interpret it? This is by saying the executive is nowhere in the scene. This is one aspect of the matter. Secondly, I will give the answer also, how the Supreme Court got over it. Secondly, in the second judge's case, the primacy of the Chief Justice did not arise in the context of the appointment of a Supreme Court judge. First judge's case was a case where the question was dropping two of the High Court judges, who were now actual judges from confirmation, and transfer of some judges to other High Courts. They were all concerned only with High Court judges. When you appoint a High Court judge, there are four constitutional authorities. When it says governor, it's the state executive. Then Chief Justice of the High Court. Then Chief Justice of the Supreme Court. Then the President means union government. When there are four constitutional authorities, the Chief Justice has the primacy was the question. Supposing all the other three says, the Chief Justice of Madras High Court says, or any other High Court says, the state executive says, the union government says don't appoint. Would the Chief Justice appoint? That will be giving a power of veto to the Chief Justice. In fact, in the second judge's case, you see, one thing is, Mr. Sorabjee had appeared in all the three cases. First judge's case, second judge's case, presidential reference. But we were each on the opposite sides. First judge's case, second judge's case, I have appeared in the Union of India. The presidential reference, he was the Attorney General. I was appearing on the other side. Therefore, but as I was telling you, in the reference, the first judge's case only decided Chief Justice primacy in the context of the appointment of High Court judges when four authorities are involved. Therefore, in the second judge's case, I made a statement solemnly in court. Please record a statement that the government, because the government had made two wrong appointments previously, the government will not appoint any judge whom the Chief Justice says I don't want. Because you can't trust a judge on a Chief Justice of India who is the head of the family. But supposing all the three authorities say in the High Court, we don't want him. Why take a risk of appointing somebody when somebody has a doubt? It's always risky to appoint a person in which there is an objection. Because it's not as if judges are not available. They are available. You don't go for them, that's all. What's more important, I got an instance which appears in a newspaper. It says, judiciary, 1 minute, yes, advocate with links to terror outfit almost became a High Court judge. This is by at a time when collegium is operating. The Supreme Collegium and the High Court Collegium is operating. I don't blame the judges. They don't have the inputs. They won't be able to get the inputs. And they say if we will advise once, if say executive returns, second time we advise, the President is bound to accept. The Constitution contemplates only an advice by the Council of Ministers to the President. It does not contemplate an advice by a Council of Judges to the President. That is why one of the most eminent judges of the Supreme Court to adorn the court, and I emphasize again, a lady judge. We have gone to this country has gone to dogs for two reasons. We did not give women the pride of place, which even the scriptures give, which are wrongly interpreted by conservative commentators who were petty commentators. The second mistake was ours is an agricultural economy, completely neglected, farmer suicide. Corporate economy is very important. That's why the country is in this total. But the eminent judge says in a memorial lecture on the interpretation made on the Constitution by the second judge's case. I will read one or two sentences. I should take time because Ram should have more time than all of us because you will enjoy his speech very much. It's a good articulation, very good articulation, and a lawyer with profound knowledge. I need not flatter him, it does not require my flattery, nor am I a person who would like flattery. But there is nobody in the country who knows more evidence like Danny. When I argue in Sharad Pawar's case, I learned something from him as the art of re-examination. A case was about to be lost. By 3 questions in re-examination, the case was won. That is my admiration for him. Now I will tell you what this lady judge says. The insulation of the judiciary from executive interference in the matter of appointment and transfer of judges is now almost complete. But the question remains, has this almost complete insulation achieved the object for which constitutional interpretation was trained to an extent never witnessed before? The constitutional interpretation was trained to an extent never experienced before or after or even after. Both ways she says. It has not. It has just changed the actors without any change either in the roles or the method of acting. One of the criticisms of the earlier law, to quote the Supreme Court, was the mystic of this process of appointments is kept secret and confidential between just a few individuals, not more than 2 or 4 as the case may be, and possibly cannot therefore be ruled out that howsoever highly placed may be these individuals, the process may on occasions result in making of wrong appointments and transfers, and may also at times, though fortunately very rare, lend itself to nepotism, political as well as personal, and even trade-off. Justice Bhagwati, in one of his interviews with the TV, said, I am ashamed of my judgment in the ADM Jabalpur case. But he maintains first judge's judgment is correct. And he criticized the present procedure by saying, this judge says, I will accommodate you, that judge says, I will accommodate you. I don't know how far these are all true or false, because none of us know what is happening in the collegium, because it's all a secret process. What is more important now, her criticism. The same criticism may be made with equal justification of the present procedure for appointments and transfer of judges. As I have said elsewhere, the process by which a judge is appointed to a superior court is one of the best kept secrets in this country. The very secrecy of the process leads to an inadequate input of information as to the abilities and suitability of a possible candidate for appointment as a judge. We saw one instance. This is the problem, they won't get the information. The solution as I see it lies not in a reversal to a status quo ante, but in the setting up of a judicial commission with all the powers now vested with the Chief Justice of India and the collegium of the Supreme Court judges. This is at present the subject matter of an intense public debate, but the suggestion is not new. In 1981, the Supreme Court itself, after noting the setting up of judicial commissions in other countries, considered etc., etc. Therefore, even as early as 1981, Supreme Court has said it. We are in the year of grace 2004. The government have woken up, they have beaten Rip and Winkle more than 20 years. Now, after waking up, it's a sudden knee-jerk reaction, as he rightly said. In fact, many of us need not know it is going to be one for the constitutional amendment, the other by way of an act. Everything has to be by constitutional amendment. All passed in one day. This is the problem. Therefore, in fact, the Commission for Review of the Working of the Constitution recommended a judicial commission. Mr. Sorabjee was then Attorney General, he was a member of it, I was a member, Pankaj was the Chief Justice. We recommended it. The problem is, the second system has also not worked. We don't know what they are for, and there will be a lot of criticism. And in private, when you converse, many judges in the high courts, members of the bar in different high courts, even in the Supreme Court, in private, retired judges of the Supreme Court, say this system has not worked, this must go. Many may not come out openly. But general feeling is that this system has failed. Therefore, a new system is necessary. All these things may be flawed. The present bill may be flawed. But that's why I said we have to take care of the persons who should be the members of the commission. And then the choice of the persons who will be judges. Because if there is one judge, then the entire reputation of the judiciary will go. One bad judge. Not like in the other walks of life. But this is one kind of service to the country. I don't mean service in the service sense. We have very noble service being rendered. That institution, we can't afford to have even one drop of poison in a pot of milk. This is the problem. And independence, we are only talking of executive. One other problem which has touched the judiciary, I should not say it because I don't want to let down the institutions, but newspaper says, quoting from a sitting Chief Justice of today, judiciary not untouched by corruption. This is very painful, very painful. This is the only institution which has to be above everything. Anything, when one judge of a high court retired, the Madras High Court, a doyen of the bar, Mr. T.M. Krishnamaya, all of whom, he was a saintly man who all of us respect, unfortunately used the word known for his integrity. The entire bar protested. Integrity is a part of the institution of a judge. How can it be separately said? It is something like saying a chaste housewife. It is an oxymoron. This was the level at which people were respecting the court. You can't think of even in a dream of corruption. If a Chief Justice says it is not as if it is not touched by corruption. It is very anguishing and painful. Therefore, independence does not mean only independence from the executive. I have collected a lot of decisions. This is not the place where to cite all of them. They say so many other considerations for a judge. Sastra, he must be learned, not only in laws, but he must be it's a literature. I think Sirvai, or I think he said so. Judges should know literature. You need any literature, English, Sanskrit, Tamil, Gujarati, Marathi. They contain values. If we used to exchange quotations from Shakespeare in Grace Elegy. You can't merely pass the law degree, put in 15 years, 20 years, either collegium or a commission or a old system. I know 3 out of 5, I am a high court judge. What is it he can do? He must be a scholar, not only learned, kapata anusara kusala. He must know all the hanky-panky which the parties are capable of. Otherwise, how does he decide? Bhakta, absolutely dignified. Nachak prodana, never lose his temper. Today, I am unfortunate, sometimes I feel judges losing temper. If you say you behaved like this, I lost my temper, that is, it is only then you should not lose your temper. When everyone is behaving all right, if you lose your temper, what to call about you? That is the occasion when you should not. And Privy Council said it in 1945. Judges are no doubt human, and their patience is often sorely tried by counsel and litigants. But it is to be regretted that judicial temper should even appear to give way, not give way. But of course, parties and counsel who are responsible to bring about the situation have no business to complain. Because justice must not only be done, but must appear to be done. It is very difficult to say which is more important. Supposing justice is done, the entire country says it is wrong. Has justice been done? Though the justice has been done. Supposing an injustice is done, the entire country says, oh, wonderful, justice has been done. Is it not better? It is a very exact question. One can't answer. That's why Rajamandar Chief Justice said in his centenary celebrations, it is the verdict of the majority, the people's voice, which condemned Jesus to the cross. Posterity condemned that verdict. We don't know where justice lies. Therefore, constitutional preamble, first you get the word justice. Political, etc., economic, etc., etc. Justice is primordial. If that has to be hold the balance, you have to hold the balance, then we require independent judges. Only if the judges are independent, the institution will be independent. Only if that institution is independent, then the bar will be independent. And only if the bar is independent, the bar and the bench being the two wings of the bird of justice, the bird justice will fly high up in the air. The moment one of these wings flops, the bird will fall down. and if that fall down, democracy is demolished. I thank you for this opportunity. More learned and scholarly people are waiting. Thank you for this time. And please forgive me if I had lapsed or taken more of your time. Thank you very much.
Now I request Mr. Soli Sorabjee to share his views. He is asking for some name of the lawyer.
I must thank the Sastra University and Times of India for giving me this opportunity of addressing you on this important topic. Now, I don't want to cover the ground which has been so ably covered by Anil Divan and also referred to by Mr. Parasaran, but I must mention two things. I was very touched with the mementos which were presented to us. Not the usual books on administrative law and constitutional law, but a fine musical instrument. That's so typical of Chennai and Tamil Nadu. Civilizing aspect. The only problem is how do I carry it in the airport? The other thing I would like to say is, right tributes have been paid to the great judges they were sent to the Supreme Court. Of course, my favorite's always been Subbarao, a great judge, great dissenter, a great judge for protection of the citizen. Among the members of the bar, Parasaran, various others have gone. But there is one member of the Madras bar for whose presence of mind I have great admiration. I'm not quite sure about his name, but Palkhiwala told him he was addressing the court and his trousers slipped. So we all thought, my God, what was going to happen? Nothing. He just took his gown across him, put his foot on the table. That happened at 12:45. He went on till 1 o'clock, and that's presence of mind. Raja Gopal Shastri. I think he's one of your greatest lawyers. Ladies and gentlemen, we have heard about this. We have talked about this. What actually is the matter? Judicial Commission. Can it enforce, can it bring judicial independence? Let's understand the historical background of this collegium system. Because you must know the past to understand the present and to redeem the future. The genesis was the fear that we don't want Sarkari judges to be appointed. And that's not some figment of imagination. That happened because of supersession of 3 judges. You know that. Sherratt, Hegde and Grover. And the floating of the theory of committed judges which were making the rounds. And the tribe of committed judges also increased. Well, it was in that context that there was a genesis of the collegium system. And let me tell you, apart from the supersession of those 3 judges, one of the most shameful supersessions was of Justice H.R. Khanna. The man knew that if he decided against the government in a case which meant so much to the people of India, the habeas corpus judgment, he would be superseded. He was. But it didn't matter. He listened to his conscience. And today, if you must know, in the Supreme Court, there is a portrait of Justice Khanna. There is not a portrait of Justice Chandrachud, who was Chief Justice, not of Chief Justice Bhagwati, who let us down at a matter, in a issue on which we expected them. That is Justice Khanna. Now, frankly, like any other human agency, it must be conceded, and it has been conceded, that the collegiate system has not worked satisfactorily. Personally, I'm not against a National Judicial Commission. But all depends upon the composition of the commission. The main argument against the collegium system is judges appoint themselves, there is no transparency, government has no voice. Well, these are valid. Can you come and put this slide down a bit? Those are valid concerns. After all, government is the biggest litigant and it must have a voice in the appointment commission. In short, my belief is, yes, you can have other voices, but the judicial must have a predominant voice, though not an exclusive voice. Why? Because judges know the laws who appear before them. The judges know the judges whose judgments they are familiar with, which come up before them. So they should really have a dominant voice, not an exclusive voice. I'm going to be short because you're all waiting for fireworks from Ram Jethmalani, so I'll be short. The other thing is, so my appeal is, don't do things in a haste. Don't throw out the baby with the bathwater. Just 5 minutes on judicial independence. What do we mean by judicial independence? Of course, the traditional thinking is that judges shouldn't be influenced in the decision by pressure from any source. Government can't do it as far as the salaries and service conditions are concerned, protected by the Constitution. But there are other blandishments the executive can really offer, going abroad on a foreign tour, head of a delegation, and so on. But the other independence important is that judge should be independent of himself, his preconceptions, his predilections, his own personal philosophy, when it comes to deciding a particular constitutional issue. The question was whether the Communist Party in Australia could be banned under the Constitution. I'm sure the judges were dead against communism. But when it came to deciding the question, they went by constitutional principles. That is judicial independence. But why go to Australia? We have a very classic case, the case of one of the greatest judges of our Supreme Court, Justice Divan. He was deciding cases of preventive detention, orders passed against communists. And I'll read you what he says. It is perhaps ironical that I should struggle to uphold these freedoms in favor of a class of persons who, if rumor is to be accredited, and the long list of their activities which is furnished to us as any guide, would be the first of them to blow up our Constitution. But I cannot allow personal predilections to sway my judgment of the Constitution. That is real judicial independence. But I ask you, friends, how are you going to achieve this? By a commission. Ultimately, it means the person must be a person of integrity, a person of character. Judicial independence cannot be legislated. Judicial integrity cannot be legislated. It has to be fostered. And to my mind, before we venture into other things, the most important thing is a vocal, vigilant, and responsible bar to ensure this process, which has suffered from aberrations, doesn't continue to do so. And I'm sure in that connection, the bar, your bar, the Madras bar, will give the lead as it has always done in matters of importance. Thank you very much. Jethmalani, I kept my promise. I cut down my speech.
Some more light there? Now, Mr. Jethmalani.
the distinguished Vice Chancellor, the Dean, the faculty of this great university, and above all, my beloved young students of the various institutions which you have developed here. It is these youngsters who, at my age of 90, keep me young. I'm a follower of the teaching of King Solomon, who, once I advised my Prime Minister, has left a prescription for eternal youth. Don't misunderstand. The prescription that he has left is that the older you get, the younger should be your company. I'm sorry I didn't mention the great audience present here, those invited guests who are all very busy people in life, who are very great intellectuals, including, of course, a judge of the High Court. I hope there are many more judges present here. And you have the great qualification of an audience, and that is the capacity to suffer for long. You have already heard 7 speeches, and mine is the 8th. So far as I am concerned, I feel like the 8th husband of Elizabeth Taylor. On the day of the wedding, he confided to a friend that I know what I am supposed to do, but I don't know how to make it interesting. I don't share the attitude of that 8th husband of Elizabeth Taylor. I am very grateful to the previous 7 husbands who have all spoken before me. They have made my task so much easier. I had about 15 pages of my notes for my speech, and before I entered this hall, I told them that please give me a little more time. Most of them promised. Only Soli Sorabjee has kept his promise. But ladies and gentlemen, I am very grateful to them because there is nothing from which I differ. I have no conflict of interest with them. And it's very funny that all the 7 are the friends of the 8th husband. They have made it very easy for me to deal with Elizabeth Taylor. First of all, let me be clear what exactly is the meaning of independence of a judge. A point which Parasaran touched, a point which even my friend Soli touched. Ladies and gentlemen, first is the independence of the judiciary in common parlance from the influence and control of the executive. That is important enough. But once again, please understand that in the pre-1993 constitutional position in India, when the executive had the veto power in the matter of judicial appointments, we still produced some very great judges. Judge like Mr. Justice Fazal Ali, Justice Vivian Bose, many others. They were great judges, and they were the products of the very system which we ultimately came to hate. It's not the fault all the time of a system. The fault is of those who man a particular system. If those who man a particular system are not independent, are ill-minded persons, or they are intellectual cowards, whatever system you give to them, they will produce evil results and will find nothing commendable in their career. It is true that even the worst system where the executive had primacy and the veto power, great judges did exist. But later on, as human character declined, because men like Sardar Vallabhbhai Patel, great distinguished Home Minister of India, Govind Vallabh Pant, another great Home Minister of India, when people like this no longer existed in India, and some intellectual and moral pygmies started occupying those great offices, the decline of the system started, and we attribute it not to the decline of character, but we attribute it to the decline of the system. So, ladies and gentlemen, even the worst system that existed under the original Constitution of India prior to 1993, we could produce good judges of whom posterity has reason to be proud. But I said that ultimately character started declining, and character started declining so much that today the politician has become the butt of jokes. Politician today is at the lowest watermark of his social acceptance and respectability. I have always been sharing the latest joke about politicians with my audience, and I don't wish to make an exception in your case. The latest joke is that if one politician falls into the river and drowns, it will be a simple case of pollution. But if all the politicians fall into the river and die at the same time, it will be the solution. Even the lawyer's profession, to which I belong, has suffered a terrible decline in the matter of social acceptance. Again, huge volumes of joke books have been produced, and those of you who are interested in knowing the best jokes about lawyers must read a book called Professor Gallanter's book, with an old friend of mine who has produced a huge book like this. The title of the book is The Profession Lowers the Bar. And ladies and gentlemen, one of the jokes in that great book about lawyers is that the pharmaceutical laboratories in the United States have decided that in their experiments in their laboratories, which they make about scientific matters and so on, they will use lawyers instead of rats. So when I heard it, I thought that there is some contribution scientists, lawyers have to make to the growth of science. I didn't feel so bad. But the pharmaceutical laboratories then gave 3 reasons why they had arrived at this decision. Reason number 1, that lawyers are more numerous than rats. Reason number 2, that it's difficult to fall in love with lawyers, as occasionally we do fall in love with our rats. And the third was a more humiliating reason, that there are certain things which lawyers do which even rats will not do. Ladies and gentlemen, I must plead guilty to the charge that I belong to both these professions. But fortunately, there is a saving grace in my life, that I have a third and a fourth profession. I have finished legal practice for 71 years. But my tenure as a teacher of law is longer by 1 year. I am still finishing the 73rd year of my law teaching. You might be surprised to know how this can be possible. Ladies and gentlemen, I qualified as a lawyer at the age of 17. When I applied, they suddenly confronted me with a rule which required that you should be 21 before you can be enrolled. So the first case which I argued in my career was my own case. I went to the Chief Justice of Sindh. I'm talking of the province of Sindh, which is no longer with us, it's now a part of Pakistan. I argued my own case and I told him, I said, sir, when my parents sent me to the law school, if they had been aware of this rule that I will not be able to support them for the next 3-4 years, they would never have made me a lawyer. How can you apply this law with retrospective effect when it did not exist when I joined the law college? It was passed only when I was already in the law college. The Chief Justice says, young man, you have an excellent point to make. I won't give you an immediate relief, but I am giving some good advice to the Bar Council. So he advised the Bar Council to make an exception in the rules, that in suitable cases you will make an exception. Then he says, young man, now you apply under that exception. I did. I had no difficulty. I had a unanimous resolution of the Bar Council, but even they found one defect still. They said at the age of 17 you are a minor. Your contracts are void. So how can you be a lawyer? So they said, we will enroll you the moment you complete 18 years of age. Ladies and gentlemen, between 17 first of all, you must understand that judicial independence is not merely independence from the executive. It is important that it should exist, because no litigant can have any part to play, big or small, in the selection of the judge which will decide the litigation to which he is a party. Today, ladies and gentlemen, particularly after India became not merely a democracy but a democratic republic, the difference between a democracy and a democratic republic is very vital. In a democracy, those of you who young students, I hope you are still reading Dassey's Law and Custom of the Constitution. In a democracy, the parliament is supreme. The majority in parliament can do anything. No court has the power to challenge what the parliament. As Professor Dassey says, that the Parliament of England can turn a man into a woman and woman into a man, but no parliament would have the right to, no judiciary would have the power to say that this law is ultra vires. It's ultra vires what? They have no written constitution, except now when they have become parties to the Rome Treaty. So ladies and gentlemen, a democratic republic is a vitally different institution from a mere democracy. And our constitution calls India a democratic republic, and the constitution makers were so very clear about the use of proper language that they will never use two words instead of one. And therefore, when they called us a democratic republic, they had a great purpose to serve. And that purpose was that sovereignty, unlike in a democracy, does not vest in the majority of the elected representatives of the people, but it vests in every individual citizen. There are certain things which even a unanimous majority in both houses of parliament cannot do. For example, they cannot say that Mr. Jethmalani is such a maverick and an inconvenient maverick that he shall not be allowed to make any speech anywhere. The law will be declared ultra vires. It will be declared ultra vires by the judges. And if at all, in a democratic republic, ladies and gentlemen, the sovereignty in a sense resides in the judges of the realm. And if sovereignty is to reside in the judges of the realm, it is obvious that the judges must have independence, because in a republic, the greatest and the most prolific litigant is the government of the day, the state. The state also includes all its agencies. And it also includes the big army of bureaucrats who are the face of the Republic of India so far as the common citizen is concerned. So if you have the misfortune of becoming a litigant, either because you are compelled to initiate it or because you have been called into court by somebody else who has already instituted a litigation, the victim of every litigation is entitled to one great requirement, that he should not have the slightest suspicion about the complete unqualified impartiality of the judges who decide his dispute. And this by itself disqualifies the executive from having any control over the appointment process so far as the superior judiciary is concerned. And ladies and gentlemen, to my mind, even membership of a political party should be considered a disqualification, unless, of course, some person, in view of his ultimately becoming a judge, at least about 10 years before his becoming a judge, he has given up his association with the working political party. Otherwise, it should be a disqualification. Because political parties are today ranged in opposite sides of the litigation, and we do not want one person to complain that the other fellow is connected with the party to which I don't belong. After all, judges recuse themselves if one litigant before them is a member of the same club to which the judge belongs. How can you have judges sitting there who are active members of a political party only the day before to decide disputes about members of another political party? So, ladies and gentlemen, that the executive has to have no voice in the appointment of judges is an inevitable, is an inexorable, it is an unavoidable conclusion from the terms of the Constitution, because we are a republic, and in the republic the citizen is usually ranged against the state and its instrumentalities. Now that is one. But ladies and gentlemen, as I said, there is something like you may be independent, but you may have other problems. And as one of my previous Elizabeth Taylor's husband said, that you should also be independent of what? You should be independent of the frailties of your own character, your own greed of money, your own greed of promotion and power, your cupidity, your other defects of character and conscience. And all these are characteristics from which a judge has got to be independent before he can call himself independent. Now the 1993 decision in the famous Advocates on Record case, which overturned the 1981 decision, the Gupta's case, is a great landmark in the history of the judiciary. I had the honor of appearing for the Advocates Association in that matter. And ladies and gentlemen, the argument that I made before the judges was very simple. That the Keshwanand Bharati case, decided long ago, laid down the proposition that there are certain parts of the Constitution of India which constitute its core, and that core or any part of that core cannot be abrogated or even diluted by even a constitutional amendment. In other words, even if you have a 2/3 majority in both houses of parliament, that core cannot be touched or diluted or abrogated. So we argued in 1993 when I appeared in the Supreme Court before the 9-judge bench. What did I tell them? I told them that please look at Article 50 of the Constitution of India. Article 50 of the Constitution of India says that the state shall strive to keep the judiciary and the executive separate. And I argued before them that this does not mean that judges and politicians should not meet in a club. This does not mean that they should not reside in the same bungalow, that they should not reside in the same locality, or that they should be compelled to reside in different cities. It does not mean physical separation. What it means is that you have no right to select the ministers or the executive. They have likewise the obligation not to interfere with your appointment. And I said that Article 50 of the Constitution of India is a part of the core of India's Constitution, and therefore you must construe the word consultation in the context of the core of the India's constitution, the core is that the executive should have no hand in the appointment of our judges. And judges not merely of the superior court, but judges of any rank, the lowest, this principle applies to all. And ladies and gentlemen, it is this argument which has been basically the fulcrum, the foundation of the 1993 judgment, in which they said that we will have to construe the word consultation as concurrence, because unless you do it, there will always be interference of the one with the other, and that will be trespassing into the field of the other, and it will be a trespass in the matter of the core of the Constitution. Now, ladies and gentlemen, let us assume that the 1993 judgments, modified to some extent by the 1998 judgment, produced the collegium system. Now look, the collegium system's defects have been pointed out. I don't disagree with any criticism of the collegium system, but ladies and gentlemen, there is some difference of emphasis. The collegium system was designed by a judicial decision to become a part of the core of India's constitution. The first criticism is that this is not legislation, this is judicial legislation. But ladies and gentlemen, the article of the Constitution says that a law declared by the Supreme Court in any judgment shall be binding on all authorities. Therefore, whenever you interpret the law, performing the role of an interpreter of a law, which is a part of the essential role of the judge, that he interprets the law all the time, if the court interpreted in the context of Article 50 that consultation means concurrence, then that has now become the core of India's constitution, and you cannot abrogate or dilute that core which has been created by a judgment of the Supreme Court in 1993, modified to some extent by 1998. But ladies and gentlemen, that core is possibly terribly exempt in every sense, even from a constitutional amendment. And that is what I argued before the Parliament on that day in the Rajya Sabha, when I had the distinction and the honor of being only one person in the whole House who sat there and spoke for 45 minutes, and I explained to the Parliament what was happening. I must record on this occasion that the leader of the opposition made a speech. Of course, ladies and gentlemen, he is not my leader because I am still an expelled member of the BJP. So that expulsion makes me completely free of all restraint. So, ladies and gentlemen, the speech of the leader of the opposition, who got up and spoke for nearly 45 minutes, from the first word to the last, could have been a part of the law minister's speech in support of this constitutional fraud. And ladies and gentlemen, Mr. Parasaran will tell you that he was present. He told you already that Ram was the only person who spoke for the opposition to this bill. I spoke for opposition against the bill because I said that the bill is a fraud. What have you done? I have no objection to your saying that you will, under which you said in Article 124A, newly added by the Constitution Amendment Bill, that there shall be a judicial appointment commission, they call it. They don't call it the National Judicial Commission. With the manifestos of many political parties, including the BJP, the BJP manifesto has talked about the creation of a National Judicial Commission. So at least I am not offending the BJP when I support the National Judicial Commission or the National Judicial Appointment Commission. But, ladies and gentlemen, having said that there will be a judicial appointment commission in Article 124A, which they have introduced, the constitution, the powers and the structure was not left to the Constitution, but was left to an accompanying bill which can be repealed tomorrow by having one member's majority in both houses of Parliament. You can exercise that majority and take away that power. You can say tomorrow, for example, I am sure that Mr. Kapil Sibal, who piloted this bill, is a very honorable man. He will not do it. And when he came to know that I was the sole opponent to his bill, and he's a great friend of mine, he has been a friend of mine at the bar, and even though he's a member of the Congress ministry, I still respect this man. I am keeping a great watch over this law ministry and how it works. And I have some praise for that man. There are honorable ministers in the cabinet. I don't say no. But when he realized that even Ram is opposing his friend, then he walked up to me in the house and he says, Ram, how are you opposing my bill? Because he had worked out a wonderful agreement with every section of the Rajya Sabha. So I told him, I said, Kapil, my conscience does not permit me to collaborate with you in this dark deed that you are performing. And I said, please tell me, you answer my question. You are now saying this is the constitution of the Judicial Appointment Commission. Tomorrow, what prevents you from repealing this and passing another bill in which you will say that the Minister of Law shall be the sole appointing authority for Supreme Court judges? Is there anything to prevent you? He said, Ram, but do you think we will do it? I said, you did worse things during the emergency. What the hell are you talking about? You destroyed a living constitution during the emergency. You are capable of doing that all over again. And please, don't tell me that you will not be able to do this all over again. And ladies and gentlemen, I did want to read to you that in my speech, I did say, and I am quoting the exact words to you, I have great respect and affection for my friend Kapil Sibal, the Honorable Minister of Law and Justice. I do not wish to expand this, lest it may embarrass him with his colleagues. That is, Ram Jethmalani's friend must be a great disqualification in the Congress party. I would not easily oppose bills introduced by him unless my understanding of the Constitution and my conscience urge me to revolt against acquiescing in such diabolical pieces of legislation. Both my intellect and conscience tell me that these bills will set up an evil precedent of Parliament, deliberately damaging a basic feature of the Constitution, making liberty tenuous and gravely attenuated, weakening the judiciary, rendering human rights vulnerable, and exposing democracy to the threat of extinction. So, ladies and gentlemen, after hearing my speech, at least some members of the BJP party realize that what Ram is saying is true, though we have expelled him. They at least staged the walkout, but the walkout was not enough to prevent the bill getting a sufficient majority, and it went through the Rajya Sabha. But I have always wondered, ladies and gentlemen, that how does India survive with so much of corruption and with so many corrupt rulers? I have a feeling maybe that it is wishful thinking. I personally think that there is somebody in the other world who is looking after us. Kuch to ho raha. There is something happening in the other world. And today I believe that we are now seeing the coming of a new dawn when the people of India have begun to realize what is the danger which we are facing today to the democratic system and to the democracy and the independence of judiciary, without which the republic is a sham. It's a joke, if you ask me. So, ladies and gentlemen, today, please now talk only of the character of judges, which has nothing to do with merely being independent from the influence of the executive. What I want is that the judge should have his own free conscience and free intellect. How do you get it? In other words, I am talking of character. And when you have fixed this subject today, will the Judicial Commission create more independent judges? Yes, it will create independent judges in one sense. They will be independent of the executive power in the matter of appointment. They need not become employees of the government, but they may still be employees of their own bad character. Now what do you do, ladies and gentlemen? How do you create? Proposition number 1, character cannot be produced by legislation of any kind. You cannot legislate good character because the whole penal code exists for creating good character. But you see what is happening every day. After that rape which took place in December last, the number of rapes seems to have increased. And that is exactly what is happening to the corruption. Every day there is some new racket discovered, and finally the CBI director, who is a slight improvement on the previous models, I heard slight, but he is just certainly a distinct improvement upon the previous predecessors of his. He registered the latest first information report in which it cannot be denied that the Prime Minister is a party to the decision. Once again, ladies and gentlemen, the Prime Minister of India, though we belong to two different political, what should I say? I won't say that I now belong to any party. But ladies and gentlemen, that we do belong to two different systems of political thought. And I am very happy that at least the Prime Minister has had the moral courage to say that I do not mind the CBI having registered this FIR, and I am quite prepared to submit myself to interrogation by the CBI. This is evidence of good character of the Prime Minister to some extent. To some extent again, because I don't wish to prejudice the action of the CBI either by a certificate of a person who has been his friend in the previous regime. In the previous regime, he had the distinction of bringing India and America together. The Americans agreed ultimately to become our brokers and go around the whole world. Those 45 suppliers who are in a position to provide nuclear material to us, the President of the United States undertook that I will persuade all the 45 to see that you get nuclear material. And I thought that he is a great, great friend of India who has got the mighty Americans, and I am afraid that even President Obama today does not fulfill the promise which his predecessor has made. Now that is big politics. India has always been happier with the Republican Party in power rather than the Democratic Party in power. But that's apart. Some of you who are interested in foreign affairs should please consider this. And ladies and gentlemen, character is the product of nature plus nurture. Nature, you get your character mainly through your mother's milk. What you imbibe during the period in which you are in the womb of your mother, some characteristics are born into you. They exist when you are born, and ultimately how your family nurtures you and how the great teachers and professors in our universities take care of your character. That is where character is made. And that is why, ladies and gentlemen, I am all for education, because the education process today is totally vitiated in this country. The education in this country gives you knowledge but no wisdom. It gives you a thirst for power, but it gives you no sense of social responsibility to the people. It produces cleverness, but it does not produce conscience. That is the failure of our educational system. And ultimately, ladies and gentlemen, the value of a civilization depends upon the manner in which you treat your teachers and professors. Our teachers and professors lead a life usually of honorable poverty. We do not exalt them to the pedestal to which they are entitled. by virtue of being in charge of the minds of the young. And I am very glad that this university is producing in its short tenure a great reputation for itself, and you have a great faculty. And ladies and gentlemen, please keep up the educational system. There is no other method of producing the character of independence of the judges from their own self. And lastly, ladies and gentlemen, I am grateful that you called me here, because this is the kind of work which I enjoy. I enjoy it more than my profession. I enjoy it more than, of course, my parliamentary career of a politician. I even enjoy it more than my third characteristic, which I had pointed out, the teacher of law, but I have also a fourth. Knowing the pitiable state of the press in this country, I have started my own newspaper, the Sunday Guardian. I am the chairman of the board. I claim that that is the one paper which writes nothing but the truth, the whole truth, and nothing but the truth. It is a weekly. I started it in Delhi. We had another center in Chandigarh, and only about a fortnight back we have started another center in Bombay now, and soon enough I will come to Chennai. I am grateful to you that you have asked me to come here and speak to the young minds, particularly in this great intellectual audience, and I am equally grateful to you for that great gift that you have given me. But I must confess to you that I have examined my family pedigree up to the 7th degree of the common ancestor, and I find that there is not one musician. I respectfully suggest that if next time you have to give me an instrument, please give me some young musician, and thank you.
Now the floor is open for question answers. You please name the speaker to whom you want to address the question, and you will find answers which will be yeah, the answers which will be more interesting than the speeches you have heard.
Has also been built by leaders of religion who have done selfless sacrifice and great teachings. But all of them today are unanimously embroiled in some controversies brought in by the government. What do you think? This also should change. Mr. Jethmalani, please.
Question addressed to who?
Mr.
Jethmalani. No, selflessness. Selfless leaders. Not just education.
I agree with you that model leaders in our public life are a great source of development of character of others. But the point is that are we producing those great people today? I am aware of the great leaders of religion in the religious field here in India, but I am telling you, and pardon my confession to you, that I have mixed feelings about religion, because in India we have called ourselves a secular state, and the meaning of a secular state is not understood. The secular state in India means the subordination of belief to this rule of reason and logic. Because when we said that everybody has the right to practice religion, profess religion, and even propagate religion, because the minority members in the Constituent Assembly asked for the third right, that we want the right to propagate religion. And Nehru and Ambedkar told them that you are asking for a very dangerous right to be created. They said, no, we want it. They said, all right, we will accept the challenge. So it was a challenge accepted, and the word propagate was added to Article 25 of the Constitution. But ladies and gentlemen, the Constitution makers were a great galaxy of intellectuals. They realized that something dangerous was being done. They made all these three rights, profess, practice, propagate, subject to public order, public health and morality. In other words, ladies and gentlemen, every religious practice and dogma will be tested on the touchstone of public order, public health and even morality. The startling implication of our secularism is that there are some religious practices and beliefs which are even contrary to morality. How will you resolve this conundrum? It can only be resolved by this small little mammalian equipment which Providence has given us. To my mind, and let me summarize to you what the meaning of India's secularism is. India's secularism mandates every citizen to lead a life totally governed by reason and logic, but inspired by this great dynamo of love, charity and compassion. There is no higher religion than that, and I summarize my own religion in one line. My one-line religion is to make as many people happy as I can while I am alive. And thank you.
My question is to Mr. Parasaran. We are speaking about independence of the judiciary. Now, state is the most litigant in this country. For every infrastructure, the judiciary has to look up to the state government or the central government, even for basic infrastructure facility. Obviously, certain compromises had to be made for this. Should we not have a separate budget for the judiciary so that independence is maintained in that sense, that they doesn't look upon to the local legislatures for sanctioning the budget? One. With regard to other question, we speak about the integrity and honesty of the judges. When the judges are in sitting or in holding the position, we give them the royal treatment. The moment they retire, we give pittance as their pension. Should we not ensure that they are paid reasonably and their rest of life is ensured with basic requirements and infrastructure? I think that will maintain the integrity and honesty of the judiciary, and they don't look upon to the post-retirement postings, which will also help.
The independence of the judiciary is still being built up and developed in view of all these controversies. I agree that they should also have economic independence. In due course of time, I hope things will settle and they will get that independence. There have been already suggestions being made from several quarters that even retired judges should be paid the same honorarium which they were drawing as sitting judges. In fact, it is wrong to call it even as salary. It is only an honorarium which is being paid for their noble services. Therefore, that should necessarily be taken care of as far as the post-retirement benefits are concerned. The problem comes in only for post-retirement benefits when they expect appointments. Then questions arise as to whether they are looking forward or forward-looking judges, or they shaping anything case looking at that. Then the question arises. That's a matter of debate that did not arise in today's debates. That's a matter of area where I feel that there should be no post-retirement assignment to any Supreme Court judges. In fact, only with got High Court judges, there can be post-retirement assignment, because a Supreme Court judge has functioned with no other higher authority over him. To take any assignment for any position, again he subjects himself to a judicial review. It looks a little anomalous. That can also have an impact on the independence of judiciary.
The people who ask, identify yourself and mention whether you are a lawyer, what you are, so that people who can answer can.
My name is Shantanu. I am into business. My question is to Sri Ram. Sir, I am totally in agreement with your view. Character can be made by nature and nurture, and your suggestion of education can make the. I would like you to, I would request you to please tell the Indian education system, which has been implemented by Macaulay, how can it serve the Indian culture and Indian education to make character in Indian citizen? Thank you, sir.
Absolutely right in your feeling. Today, if you talk of development of Indian culture, Indian civilization, and the ancient ideas of India's very ancient and enviable civilization, you will be considered a communal-minded person. The word secular has become a word of political abuse. I am secular, my opponent is communal. Now this is the tragedy of India, and that is why you find that the third-class institutions in which neither reason nor logic nor freedom from dogma and the development of the scientific spirit are talked about, those institutions get good grants, but other schools and colleges and universities which don't do this kind of dirty job for people, they get no kind of help or sustenance. So you are right. Again, democracy, you are the sovereign of the country. You have to cast your votes properly. Democracy is a swimming pool. If you don't periodically change water, it becomes a cesspool. Find out today whether it has become a stinking cesspool already or not. If it has, please have the courage to protest and say that you shall change the water.
Good evening, sir. My question, good evening. I'm Srimati, my name is Srimati, I'm a lawyer here in Madras High Court. My question to Mr. Ram Jethmalani is, as regards judicial independence, should judges share dais with politicians who are facing criminal charges or some kind of prosecution? And should judges of court occupy the same dais?
Well, if
Thank
I were
you,
a
sir.
judge, I would not. In fact, you know, as a law teacher, when we started celebrating the law day in our college in Pune, we designed an oath to be taken on the law day. And one of the parts of that oath is that I shall not by my conduct lend respectability or encouragement to any person of a dubious character. Now, if the judges were to listen to this, they probably will not associate with such bad characters. And even if they do, they should do for the purpose of showing them that there is a better method of living in this world, there is a better art of life, and a better code of social behavior.
I am Rangarajan, advocate practicing at Chennai. The question is to Mr. You have excellently argued that the character is going to be built only by new excellent education. It's a very correct one, but in a long run, in a final disposal, it can be done as an interregnum period, interim relief now. Presently, even that can be done only by the proper good governance and straightforward government. I don't know whether in the short run, whether we are going to get the relief from the corruption and from nepotism and favoritism.
Again for me?
Yeah.
Yes, again for you, only for you, sir.
You have another character, politician.
Well, I don't know whether you are really asking a question. You have given me a statement of yours which you want me to accept. I have no difficulty in accepting it without any modification.
Good evening, Mr. Sorabjee. I'm a journalist with the Times of India. This question is for you. We constantly hear about political interference in High Court appointments. How does the Judicial Commission have a bearing on High Court appointments? Does it have any bearing? Do you think it will improve or in any way change the situation?
Same principle will apply. whole idea of judicial commission, whatever name you call it, is to see to prevent executive interference in what? In appointment. Why? Because we don't want sarkari judges. Judges who will bow to the will of the executive. That's the whole problem. As I said, collegium system, that was the genesis. It hasn't worked very satisfactorily, but don't throw it out. Try and improve upon it. And the best way to improve upon it, I tell you, as I said, a vocal bar, a vigilant bar, a responsible bar, and ultimately will depend upon the character of the people who are selected as judges. And you can't legislate character. There I agree with Ram Jethmalani, it's a wrong process. Education and inculcating the right values. I want to say one thing which everyone has omitted. We have in our Constitution Article 51A, which prescribes certain fundamental duties. And some of them are to develop the scientific temper, to renounce practices delegated to women, superstition, and to strive to higher levels of excellence. So these duties also are important for all citizens to perform, and that will in the long run lead to formation of a proper character. Long-term remedy, but you must make a start in that direction.
Namaste, I am Ishwaran, a retired bank officer. Yesterday we celebrated the RTI Day. As seniors, you have guided the youngsters of today to leave a good legacy and a good heritage for the coming generation. In this connection, many political parties have been trying to cull out the information of the Swiss banks, balances of our politicians and others. When will this happen? Can the judiciary be of help to the common man whose feelings are very much centered on this? Again, our Prime Minister has once used the word judiciary outreach, which has hurt the feelings of the citizens. Thank you, sir. This I am addressing the days. Anybody can answer this, sir. Thank you.
I think Anil Divan may be able
I would have answered this question, but my counsel is present here, so I'll request him to do that. Anil Divan is my counsel in the Supreme Court.
Incidentally, I was his counsel when he was detained at the Misa during emergency.
I'll tell you the position of the case just now, before I answer the question. We had a very great judgment from Justice Sudarshan Reddy and Justice Nijja, on 4th of July 2011. And then Sudarshan Reddy retires after 4 days. So the government came out with an application saying the SIT, the Special Investigation Team, was directed to be headed by Justice Divan Reddy as chairperson and Justice M.B. Shah as vice chairperson. All the others are bureaucrats. Now the government got so nervous that they applied for a recall of this direction. So Sudarshan Reddy having retired, it went before a bench of Altamash Kabir and Justice Nijja. After 4 days of argument, Justice Altamash Kabir said, this application is maintainable. That's all. Didn't decide the application. Nijja, of course, deferred. With the result that today it is in cold storage. In spite of the fact that efforts were made to get a hearing or a third judge, that has not succeeded. So that's second. Now we wanted to know whether it can come back from the Swiss accounts. If the present administration continues, it's not possible. If the present administration is thrown out in the next election, there is a very distinct possibility.
The question answer session closes.
Excuse me, last question.
Anil bhai, can I, as your client, add a few, one or two
Can
things?
I ask a last
No,
question?
please tell us the inside story. Huh?
No. I only want to tell you, all people to exercise a little bit of common sense. And it is this, that the German government gave a bribe of $475 million to a Swiss bank and got the names of all the international thugs from all over the world who had bank accounts in that bank, the Liechtenstein bank. And the Germans then made an announcement publicly that we are willing to share this information which we have now got about the culprits with every government without cost, without condition. If I was the Prime Minister of this country, I would certainly have gone to Germany that minute and brought back the names of the rascals. And by now they would have been in jail. Nothing happened. On the contrary, they have taken every possible step to see that the names are not supplied. Now this is point number one. Now point number two. Point number two is that if my name as an opposition leader or opposition member or another friend of mine, even Anil Bhai, my counsel, if we had bank accounts and our names were in this, be sure that we both of us would have been in jail. Now why are these names not being disclosed? They are not being disclosed because they are not names of people whom they dislike. They are the names of those whom they like. And I have said in public that I strongly suspect whose names they are, and they are the names of those who are leaders of your party. Why don't they have the courage to prosecute me?
So I am extremely happy to give what I believe is the conclusions of the speeches with profound backing of the knowledge, the history, the judicial experience and the knowledge of law of these four great men who kept us enthralled for the last 1.5 hours, is that there are 5 propositions on which there is complete unanimity among all the 4 of them. Even though Mr. Parasaran was arguing on the other side in 1993 as well as 1998 as well as in 1982, and Mr. Soli Sorabjee and Mr. Ram Jethmalani, and I don't know where presidential reference. So you can see these 2 gentlemen, these 4 gentlemen had been on both sides. That means they have been opposing each other in regard to how the appointment to the judiciary must take place, what should be the relationship between the judiciary and the executive. But see the 5 propositions on which they are unanimously agreed. First, the collegium experiment has largely failed, though it was a well-intended one, and the judiciary must have the final say in regard to the appointments as well as the transfer as well as the disciplining of the judiciary. This experiment has largely failed. But the 1993 judgment in the second judges transfer case as well as the 1998 reference still constitutes the law, and that should be observed because this is part of the basic structure of the Constitution. And the bill, the proposed bill, particularly the bill which will decide the constitution of the Judicial Commission, not through the constitutional process but by an ordinary law, as it was explained by just 1 vote of Parliament, a law minister can constitute himself as the sole appointing authority. The danger that is there and that is authorized and that has almost passed through, except for that arithmetical error which did not allow the bill to be passed in the Lok Sabha. So the bill as it is proposed today, as it is pending before Parliament, is a very, very dangerous proposition which can dynamite the independence of the judiciary. Third thing, for the fourth thing, it is not independence from the executive which is the real test, which is also a test, an important test, which law can ensure, which a constitution amendment can ensure. The more important thing on which all of them agreed is that there has to be personal integrity and freedom from personal prejudices, for which a larger educational undertaking is needed. A vigilant public opinion, a far-reaching understanding about what is the purpose of education and what is the purpose of this nation and what is the core of this nation. As Mr. Jethmalani said, that there is a larger idea of India, which if it is talked about, which it is articulated, which it is argued, the person can be easily classified as communal. And this public discourse is so distorted and so deviant, it requires a larger correction. It's a larger issue and a longer issue. But meanwhile, political correction can take place. That is one of the subjects which was discussed, on which also Mr. Anil Divan and Mr. Ram Jethmalani said, political correction can take place, and the swimming pool, the water can be changed, and that may be a check on the drift that is taking place. I am extremely happy that I had the opportunity of being with my friends, and this has served one purpose. The debate has started in Chennai. Chennai is the place where the debates will start, according to Swami Vivekananda, who delivered the lecture, My Plan of Campaign, in Chennai, and that is where he laid down the plan for the entire country. And we are celebrating the 150th anniversary of Swami Vivekananda's birth. And I suppose Chennai has taken the lead, and it will go and spread to other parts, and we will ensure that there is a proper debate on this, and the Parliament, as it is constituted today, should be stopped from going ahead with this measure, which is bound to undermine and dynamite the judiciary of India. Thank you very much.
Thanking is the most explicit form of courtesy, and I now call upon Mr. Nainam Tariyal, Vice President of Times of India, to deliver the vote of thanks.
Respected dignitaries on the dais, members of the legal fraternity, ladies and gentlemen. At the outset, I would like to thank eminent jurists Mr. Ram Jethmalani, Mr. Soli Sorabjee, Mr. K. Parasaran, Mr. Anil Divan, and veteran economist and journalist Dr. S. Gurumurthy for accepting our invitation to be part of Lawgical Connect, the roundtable discussion organized by Sastra University School of Law in association with the Times of India. Before the term the fourth estate came to refer to news media, earlier writers had applied the term to denote lawyers and even the common masses. Both the press and the judiciary, like the other estates, share certain public responsibilities of keeping checks and maintaining balances. While the fourth estate does this in letter and spirit, the judiciary does this in thought, word, and deed. We here today were witness to a rare evening where eminent jurists and the media, the fourth estate, came together in one platform to throw light on a subject that has been gaining significance in recent times. The judiciary and media in India have been playing an increasingly proactive role in protecting the rights of the citizens. If not for them, our country could be trudging on a different path altogether. Ladies and gentlemen, this unique confluence of eminent jurists, a media house, a law school, and general public is an event rarely witnessed. The topic, does Judicial Commission guarantee judicial independence, discussed today is pertinent to all of us. The recent Constitutional Amendment Bill to create a Judicial Appointments Commission, which will replace the collegium system of appointing judges to higher courts, has raised concerns over judicial independence. The objective of this forum was to get to the heart of the issue. The audience, including me, was witness to a very riveting discussion, and I am sure we all will leave with a greater understanding of the Judicial Commission to form our own independent opinions. I would like to thank Professor R. Sethuraman, Vice Chancellor, Sastra University, and Dr. Vaidya Subramaniam, Dean Planning and Development of Sastra University, for the original concept and for partnering with the Times of India for this event. I thank and congratulate the students of Sastra University School of Law for working together with us seamlessly in organizing this event at various stages. I place on record our appreciation for